So I wanted to start by talking, so how many of you guys are actually engineers? And I don't think we have many lawyers here, do we? No? Used to. Oh, congratulations for getting out, as they say. Okay, so what I wanted to do to start off is just talk just some really high-level basics about the patent system, some really high-level conversations about software patents in general, and then I want to kind of bring it back to open source and what's particularly wrong, what I think can be done better, and what I really want, though, is to have a conversation with you guys. So raise your hand at any time. If you have any questions, if I get too legal, interrupt me, please. I think it's really important, and I think this is a really important part of what EFF does in the field, and it's we work in this space which is often really legal, or in the courts, or with Congress or policymakers, and try and take these policies that don't make sense for people on the ground, all of you, and make it work somehow. So that's why these conversations are super important, and why I'm so excited to be here. All right. So the Constitution actually talks about patents, which you might not know. Article 1, Section 8 says, in short, to promote the progress of useful arts by securing for limited times to inventors the exclusive right to their discoveries. So this is kind of a funny concept, right? If you invent something novel, you're going to get a government-created monopoly to exploit that. A patent lasts 20 years. Copyright lasts like life plus 1,000,000 years, so that's a total other problem that we can talk about another day. But the patents, they last for 20 years, and the Constitution talks about them, so they're really not going anywhere. They've been around a long time. Now, in theory, this kind of makes some sense, right? There's a bargain. You invent something, you put a whole bunch of energy and effort into inventing it, and so for 20 years, you get to exploit it without much competition. But at the end of that 20 years, what you need to do is give back to society your invention in full. This is how you use it, this is the best way to do it, this is what the invention is. Now everyone go and make it better. That is how the bargain is supposed to work. What we've seen is that it doesn't always work like that, and it especially doesn't work like that when we start talking about software. There are many reasons why this is the case. I'm going to give just a quick background on that. First of all, before the 90s, there were no software patents. They just didn't exist. There were some court cases. They worked their way up to the Federal Circuit in DC, which is the court that deals with patent issues. And in the mid-90s, throughout the mid-90s, eventually the Federal Circuit ended up at a point where they said, okay, you can get patents on software. And the actual working of the software. Before, software was protected by copyright, in some instances trade secret, but now it's covered by patents. So the software patents are still pretty new. So there's still a lot of confusion about how they work. And people in the patent office, the patent examiners, I think there's still some confusion about when they're granting them. It's just a big mess. And there are some particular reasons why patents don't make sense then when we're talking about software, and why I think the courts were wrong to kind of let software patents exist. And I actually would be remiss if I didn't say that just a couple of years ago, the Supreme Court decided a very famous case called Bilski, B-I-L-S-K-Y. That case wasn't about software, it was about a different business method. And it gave the court an opportunity, the Supreme Court now, an opportunity to get rid of software patents. The Supreme Court did not take that opportunity, so we're stuck with them for better or worse. Here are some of the reasons software patents don't work. Number one, I firmly believe, and I think many would agree with me, that 20 years is too long to protect software, for a bunch of reasons. So 20 years might make sense when you're talking about getting a patent on, let's say, a drug, a pharmaceutical drug, because you have to do all of this testing at the FDA, and it takes all of these years for your drug to be to come to market. So then, you need some time to exploit it afterwards, because you've made a whole bunch of investments to get that drug to market. With software, that's usually just not the case, as many of you know. I'm not saying it's easy to code software. For the life of me, I cannot do it, but I don't think it makes sense to give a 20-year monopoly. It's particularly dangerous because, as you all are well aware, software is uniquely situated as a building block technology I write a little code, you write a little code, you make it better. That's how it works. But if I own a patent on code that I've written, you, in theory, can't even test your invention on top of my code because that's using my patented invention. So I could theoretically sue you for this, which is why 20 years is way too long. The patent system also, an important piece of the patent system is what's called its notice function. I talked about this a little bit a couple minutes ago. The idea being that I get a patent on something, I lay out specifically how my invention works, so I kind of dedicate it back to you. This does a couple things. One, this gives society a roadmap for how to use this great new invention, whether it be software or a drug or some kind of machine that makes widgets in a factory. But it does another thing that's really important, is it puts future innovators and future inventors on notice of what they can and cannot do. So let's say you guys wrote a piece of code, you wrote some software, you're really super excited about it, you think it's a great idea, no one's really done it, you want to make sure that no one else has patented this. Not necessarily because you want a patent, but you want to make sure you're not infringing anyone else's, right? So you're not stepping into a huge mess. Well, these patents, I really should have brought some bad ones. I'm sorry I didn't do that. You guys can all email me at julie@EFF, and I can show you some terrible examples of these patents that are impossible to understand. Oftentimes, the inventor, who him or herself invented the invention before they kind of handed it over to the lawyer, doesn't understand what came out. It's in the lawyers often want the patent to be as broad as possible because the technology moves so quickly that if a patent is written broadly, they can assert it against more downstream users that they didn't think of at the outset, right? It's in their benefit to have something that encompasses more potential defendants later. But in doing that, they make the whole thing totally confusing. They're really hard to understand. Lawyers most of the time don't understand them. Engineers don't understand them. People spend years and literally millions and millions of dollars litigating a single patent just to try and understand them. So, because of that, patents do a really crappy job of putting putting users or inventors on notice of what they can and can't do because no one understands what's in them. They don't really lay out this roadmap for what's patented and what's not. And also there are hundreds of thousands of patents that could potentially touch on any kind of invention. So it's really hard to stay abreast of the system and know what you can or can't do. Part of that problem is inherent to software. The language, when you use English to talk about software, we've seen reports, the FTC has said time and again that the language used in software patents is just more confusing. Also, because the technology moves so quickly that if someone files for a patent and it takes years to kind of snake its way through the patent office before it actually becomes an issued patent, in those instances, you'll get a patent and your technology could be obsolete already. And that leads us to a really huge problem that I imagine we'll probably talk more about over the course of the next 50 minutes or so, and that is the patent troll. The patent troll is, for those of you who are not aware, usually a company, but it could be a person, it doesn't really matter, who owns a patent and doesn't invent it, or doesn't sell anything, doesn't make anything, but just kind of asserts that patent as a weapon. Think of the troll under the bridge, right? So let's go back to my example about someone who tried to get a patent and it took so many years to get the patent and their technology became obsolete by the time they got an issued patent. So now they're sitting on this business that maybe isn't making a lot of money. They spent thousands of dollars getting a patent and they realize they need to start monetizing what they have left, right? And in some instances, that's going to be some patents. So that's great. So what do? They go into the marketplace and they go to sell those patents. And they sell those patents to the highest bidder because that's what most people do when they sell things. And the highest bidder happens to be one of these trolls. Well, then what happens? So now you've got this patent troll who's realized that he can make some money by using this patent as a weapon. And he does that, or she does that, or the company does that, by going around and threatening to sue companies, people, individuals who allegedly infringe the patent. Now, the way the business model works for the patent trolls is that the patent troll will ask the defendant for some kind of licensing fee. You know, pay me $10,000 and I will just go away. I won't sue you. And in most instances, this troll is going to know the perfect point, the right amount of money to ask for, that you can just afford it, and it will be cheaper than going to court and defending your rights or challenging that patent. So it's kind of a cash cow, right? You see how that goes. And these patent trolls can kind of hold businesses hostage. I'm going to talk probably a lot more about the patent troll problem throughout, because this is something that has been particularly troubling with software patents, and even more particularly troubling when we start talking about the open source community. But there you have it. That's a problem with patent trolls. There are a bunch of other problems with the patent system that I think disproportionately affect software. There's some things about damages that make it more difficult. And we can talk about more of that later, or I've got a bunch of writing on that on the EFF website. If you really feel like talking about that, you can also ask me. But I'd rather kind of talk about, there's a question? Yeah?
When we talk about patent software, are we talking about proprietary software, or open source?
Anything.
Can open source software be patented?
Sure, and we're going to talk about that. So, you know, the question is, can you patent open source software, or are we only talking about proprietary software? You can patent anything. That, whether you might have, well, let me take a step back. According to the patent system and the laws of the United States, you can patent anything, whether it's proprietary or open source. If you're using open source software and you've signed some kind of agreement, you know, GPL or Apache or whatever, you probably can't patent it, but that's because you've promised you wouldn't. Right? So that's a different thing. Legally, you can, but by a contract, you might not be able to. Depends on the terms of which contract you're using and what you've done with it. So, all right, that's the background. So now, there are a couple other things I think that are particularly relevant to open source community when we start talking about the patents. That was a good question and a good foray into this. One is that open source, I said a couple minutes ago that software is uniquely building block technology. Well, that's particularly true when you're talking about open source. We build on what the person before us has done, and that makes it a lot harder when you're trying to navigate the patent system, either as a potential defendant or just trying to figure out what you can or can't do. The nonprofit nature of many open source products make it really hard to navigate the patent system. The patent system takes millions of dollars to compete in. So that is another problem. And then open source largely depends on standards. And it's been difficult in a lot of instances to figure out ways to navigate having to have standards and not. So let me put this another way. If you are trying to comply with the standard and someone alleges that that standard is patented, then that person can sue everyone who follows that standard, in theory. Question?
Yeah, actually, when it comes to patents and standards, there has to be, the standards organizations won't allow patent to cover inventions unless they license or will license at a reasonable rate to anyone who wants to use the standard.
Well, right, so.
You're going to have to pay to use the standard like the ARP3 and so on.
Sure. But you know, what you see then is that there's a lot of room for capture. So yes, you know, they won't use a standard, will make sure that they won't use a technology that's patented, but that doesn't mean a third party can't come in and assert a patent and say, oh hey, all of you infringe. So that's where you can fall into some pitfalls down the road. And I think that's incredibly troubling. Another interesting development in the law, and I think that you're going to see more and more of this in the news, is there's a problem with injunctions. So I'll try and make this as not legal as possible, but briefly, if a plaintiff who owns a patent brings a case alleging that someone infringed that patent, they can get a couple kinds of damages if that's true. They can either get damages, you pay me because you infringed my patent, or you can get an injunction. I'm going to shut this down. You can't sell your product anymore. The second thing is in most instances, a lot rougher for obvious reasons. So the courts have kind of fixed this. They've made it harder to get these injunctions. But there's this body in DC called the International Trade Commission, and this is where many patent fights take place. Technically, the ITC, the International Trade Commission, is set up so that it protects, you couldn't, in theory, sell infringing products from abroad into the United States, hence trade. But it's really been abused by a lot of patent trolls, and this standard that makes it harder to get injunctions doesn't exist in the ITC. So patent trolls are bringing these suits, or even just threatening to bring these suits in the ITC, threatening to go after all kinds of companies, all kinds of software companies, proprietary and open source, and threatening to shut down the business. So what happens is the companies, they kind of have to pay off the trolls to go away or stop doing their business. This is really bad news, especially because one of the things the ITC is supposed to take into account when it decides if it's going to issue an injunction is the public interest. So how would it affect the public interest if you could no longer sell your product in the United States? And there are a bunch of factors that you think about here. Well, is there a competing product? Would Americans be worse off or better off? But as a practical matter, the ITC does not consider public interest, despite their mandate to do that, which is unfortunate, and we are actually working to come up with ways to make them do that. And I think, like I said, you're going to hear more and more of that in the near future. Some folks are pushing in DC to make it a law, and I just think that that's where a lot of, that's going to be the next step of patent reform. Speaking of patent reform, there's a giant patent reform legislation bill passed in 2011. It pretty much did nothing on any of these issues. But it means we're unlikely to see anything else come out of DC because it was 60 years in the making, essentially. The other thing that's pretty disturbing about patents is that what's called the hold-up value of a patent is really different than the real value of a patent. So the hold-up value basically means that I can stop you or anyone, if I own a patent, I can stop you guys from doing is way different than the actual value. If folks have resources to actually fight those patents, I think you'll see that a lot of those patents are either invalid or they're overly broad and should be narrowed. But we don't ever get there because the resources required to do that are so extensive, and so many people would rather be growing their business, making more products, working on marketing, all of these things that actually do help the economy. So one thing actually EFF is doing about this that's incredibly interesting, and you guys should feel free to come up if you want to talk about this. I'm not sure if you all have been following Code for America and Civic Commons and groups like this that have been helping develop open source tech solutions, which I think is really great, especially for municipalities that don't have a lot of money or maybe haven't really kept up with tech solutions and are way behind. One of these tech solutions is bus tracking software, right? Like when you look on your phone at Next Bus to see when the bus is coming. This has been a really good development for a lot of cities who are trying to encourage use of public transportation and all of this. Well, there's a patent troll based, I think, out of Luxembourg, called Arrival Star, who owns a bunch of these patents that essentially just cover GPS monitoring of where a vehicle is and telling you where the vehicle is. And they have gone and sued all of these municipalities all over the United States. A lot of small cities, some bigger cities, they've sued the federal government for the USPS, FedEx for package tracking. And all these cities pretty much just have to pony up and pay the licensing fee because I'm sure all of you realize right now that cities are not really in good financial shape for the most part. So instead of fighting a patent battle, they're going to pay this person to go away and go back to, fixing schools or whatever, zoning or whatever the city governments do. It's not fight patent battles in federal court. So what EFF has done is picked out one of these patents that's been used against a bunch of municipalities, and we put out a call asking for folks who had prior art, which is how you invalidate a patent, show that it was done before they got the patent. And it turns out systems like this were in use all over the world before these folks got this patent, which was about 1999. And what we'll eventually do is file what's called a re-exam in the patent office and say to the patent office, hey, this patent was crap. And not only is this patent crap, but it's being used offensively in a really bad way that's having a negative impact on our cities and on these important things that are happening in the economy. And so we think, Patent Office, you should go back and look at this patent, and we think you should throw it out, because you never should have granted it in the first place. And if you don't throw it out, you should at least narrow it. And if you narrow it, maybe they won't be able, the owner won't be able to use it.
This is part of a larger project EFF's been doing for some time called the Patent Busting Project, where we go after particularly bad software patents that we think shouldn't have been granted to start. It is admittedly a small drop in the bucket, but I think it is important to push back and fight against these people who use these patents offensively like this. And I also think it's helpful because in collecting all of this, what we call prior art, all of this proof that the patent had been used before, we can make that prior art publicly available. So when the next person is sued or threatened by this company, they can say, oh, hey, wait, I know that your patent is a bad patent. I know that people were doing this before. Here's my proof. And they don't have to hire a lawyer to dig up that proof or spend all this time searching on the internet themselves, because hopefully we'll be able to make that an easier process for them. So that's our patent busting project, and it's really great. So if you guys are interested or know anything about bus tracking software from the mid to late 90s, do please let me know. We're always looking for more. Anyway, I'm going to move on and talk about a case that is also has a pretty large impact, I think, in the open source world with regard to patents that came out of the Supreme Court earlier, or late last year, called Microsoft versus I4I. Briefly, what happened there is that I4I sued Microsoft, claiming that its XML editor, Microsoft's XML editor, infringed I4I's patent. A jury awarded $200 million in damages. The judge bumped that up to an extra $40 million and told Microsoft that they had to stop selling the product with XML in it. I would never thought that EFF was going to file a brief on behalf of Microsoft, but we did. It actually happened. And we filed in the Supreme Court because essentially what is going on here is if you've got this prior art showing that an invention had been practiced before it was patented, you can say, right, this patent's invalid, never should have been granted, and courts throw up patents that are bad for that reason. But you have to show with what's called in the law a burden of proof, right? Preponderance of the evidence, or clear and convincing evidence. Basically what this means is, what do you have to show the court in order to prove that the invention wasn't new? How hard is it to make that proof? And the courts below, it said, it's really hard. You have to show us in writing, you basically have to show us the source code that this was happening, as opposed to maybe instruction manual or some other screenshots or maybe some other artifact of how the program worked. And keep in mind, we're talking about programs that are 15 years old and might have been kind of obscure. So it's not always easy to come up with the source code, for example. Unfortunately, we lost. Microsoft lost that case to I4I in the Supreme Court too. And this leads to a really bad place where it basically says, you might need a full set of source code to prove that this idea was not new at the time. And this makes it really hard to invalidate bad patents. And this is not good. And this is especially not good when you start talking about the open source community, because the open source community doesn't always do such a good job of retaining its records. It's not always so organized, finding old code that might have been built upon later, right? So maybe you need the code as it existed in 1992, but it was changed in 1993, and it's really hard. Who still has that 1992 version? And because this was done over a network of folks, it's hard to pin down. Someone lost his hard drive. Someone else, she's gotten 3 new computers in the meantime. It's a mess. But it makes it really hard to find the kind of invalidating prior art that people really need to get rid of bad patents. And this is really unfortunate because the open source community has so much of this great invalidating prior art, right? So much interesting stuff was happening, and still is happening, of course, in the open source community. And if we can't take advantage of what's out there to show that a lot of these patents that maybe were improvidently granted in the late 90s and early 2000s if we can't show that they were obvious at the time, then we can't get rid of them. And the Supreme Court made it harder to get rid of them with this Microsoft case. So this case is not good news. The other issue that we've been following as it relates to the, what we see with open source community is third-party participation in the patent office. So there are certain people who are in front of the patent office all the time. Certain players who are always getting patents or, mostly people who get a lot of patents, companies who get a lot of patents. And then what you see is you've got parties, smaller developers, the open source community is a really good example, who aren't usually players at the patent office, but then all of a sudden they're facing a lawsuit, and it's like, oh no, now what? And they're being dragged into this patent world that they haven't really been part of, so their voice hasn't been heard as the patent office sets a whole bunch. The patent office often sets new rules. It's what's called rulemaking, the new procedures for how we all operate with the patent office. But they don't ask you guys how the rules would work better for you, right? They ask the big companies. So EFF's trying to file more documents with the patent office explaining how the patent office affects people who maybe aren't always practicing in front of the patent office. Because when the patent office issues a bunch of really overbroad or confusing or frankly bad patents, you guys feel the effects of that. So we've seen many instances of third parties who do want to participate when they're given the option. One great example is a program called Peer-to-Patent. And Peer-to-Patent shows that third parties, like I said, want to participate. In its first 2 years, the Peer-to-Patent website had more than 74,000 visitors. And of those I'll explain to you what they did in a second, but this is a really big number. Basically, the way Peer-to-Patent works is, let's say I file a patent application. And in order for my patent application to move a little bit quicker through the system, I say, okay, I'm going to use Peer-to-Patent. Here's my patent, put it on the website, and everyone in the world can look at my patent, or my patent application, sorry, and say, this is obvious, or someone was doing this before you, or I think this is a bad idea because, and then they send all of that in. That's called peer review, right? They're crowdsourcing. They're crowdsourcing the patent office's job. And this is obviously a really good idea because when you crowdsource things, you get better information and you end up with a patent that is either not granted if it shouldn't be, or is more narrow, which is half the battle, right? Trying not to cover more than they actually invented. So of those 74,000 visitors, more than 2,600 peer-reviewed patents, and in more than 25% of those peer-reviewed patents, there was additional prior art sent to the patent office that the patent office didn't know about. So now those third parties who helped peer review, who helped crowdsource, have been a part of the process, not because they were getting a patent, but because they're playing a role in making sure that the patents that come out of the patent office are better, of a better quality. And that's important. And I think that a lot of people involved in the open source community could help out with this. And it, really, some people spend hours and days looking for prior art, but some people just look at a patent and say, oh, hey, I was doing that. I know exactly where I can find this, this publication that explains how I was doing this, and shoot it off in an email, boom, 20 minutes, done. And that can be really, really helpful. Yep.
So a lot of the time, people end up being told by their employers or et cetera, actually don't look at any patents.
Right.
So don't even look at them because it actually is a greater risk if you know about them and et cetera. So how do I reconcile that with something like peer patent where you're specifically going out?
Right. The question was, oftentimes employers recommend that people don't look at patents because once you have knowledge of a patent, you might be in bigger trouble if you're caught infringing. Well, first of all, I'd reconcile that with peer-to-patent. Peer-to-patent covers patent applications, so you can't be infringing an application. So with peer-to-patent, that's kind of a separate thing. But I think that's a really important, the larger question you ask is a really important question. What do you do if your employer says don't even look at patents? Frankly, the law is kind of messed up on this point, and your employer might not be entirely wrong that you'd have a harder, basically the way the law works is if you have specific knowledge of a patent and then you're infringing it, your damages could be tripled. But this is first of all, the odds of that actually happening and going through a whole lawsuit and getting there, I mean, this happens, I can count the number of times in a year across the country. It's just not that common. But the truth of the matter is that these patents are so confusing and so vague that I think a lot of folks won't even, you'll read it, and you're an engineer and probably know a ton about the way the technology works, and you'll still read it and be like, I'm not doing this, or I don't even know what this means, because it doesn't make any sense. So I mean, it's a problem, and I don't have the perfect silver bullet answer, unfortunately. I wish I did. But I do think projects like peer-to-patent, and there are a couple, Article 1 partners is another example. They actually give rewards. If you find the best prior art, monetary rewards. It's a for-profit concern. It's called Article 1 partners. You know, these things, this is a good place to get involved in it. It's a way that I think folks can use their knowledge that they probably already have really constructively. Question?
Yes, as far as putting the patents up on, peer-to-patent or Article 1 partners or anything like that, it's the patent applicants who choose to put their, I'm just curious what.
Well, not Article 1. I should really quickly, let me really quickly distinguish. Article 1 does a bunch of different things. One thing Article 1 does is say, something similar actually to what I said EFF is doing in trying to bust a patent. Article 1 might say, someone might pay Article 1 or whatever. We're trying to get rid of this really bad patent. Send us your prior art. But peer-to-patent, yes, the applicant chooses to put up her application, but go on.
I'm just curious, I mean, what's the applicant's motivation for putting their application up there? Because you think that if they're putting their application up there, there's not a huge worry about it getting invalidated if it's passed. And if they're not, gung-ho about getting their patent passed, why even file?
Right. Well, I do think, first of all, the numbers show that if you put your application on peer-to-patent, your application goes through quicker. And most of them still get patented. I think actually they all do. It just might be more narrow. But if you're a patent owner, some people will tell you they want a patent that's as broad as possible so they can scare away as many downstream users as they can. But there are a lot of people out there who just want to patent their want to do it for the right reasons, if you will, which is patent my technology and make sure someone's not doing the exact same thing. And you have a stronger patent if you're going to face future challenges, your patent will be stronger if it's been up against the best prior art in the patent office, right? You'll end up with a patent that's that when you use it, either in court or otherwise, if someone challenges it, odds are you're going to be on the right side of that challenge because you've put it through more rigorous testing, frankly, is what we're talking about. And plenty of people, it turns out, want to do this, especially people who want to push things through quicker. So it's good. I mean, this is good. And I should say the Patent and Trademark Office is also in favor of this. They've tried to put more money into this program. It's a really good program. Well, it's not. It's run through another nonprofit organization, but the Patent and Trademark Office is working with that organization. They have a role in it. And the last I saw, the Patent and Trademark Office was helping to fund it. There was a lot of weird funding problems at the end of last year, and I'm not sure where that money ended up. But it was in their budget to help fund it. I just don't know if that ended up happening. I really quickly wanted to talk about one other thing that I hope is going to be making some news in the near future called the defensive patent license. This is a potential solution to a lot of these problems that we see, in the patent world where, listen, at the end of the day, the problem is that patents, especially on software, have become essentially a tax on innovation in America. You open a new business in the United States and you start doing really well and you're going to get hit with a lawsuit. I mean, we see this time and again. So we're trying to come up, Congress didn't fix it with its legislation last year, and the courts haven't really fixed it, but every day developers are facing patent challenges. And really that's not, I want developers to be developing and innovating and creating new businesses and not fighting lawsuits. So we've been working with a bunch of folks to try and come up with maybe some creative ideas, maybe some solutions that are outside of the courts. One in a paper that's about to be published, it's not been published yet, by Jason Schultz and Jen Urban at Berkeley, is called the Defensive Patent Licensing Scheme. This would be a completely voluntary scheme. You would not have to do it if you didn't want, but if you own patents, you could dedicate your patents to this defensive patent licensing arrangement. And let's say 5 of us dedicate our patents to the same arrangement. Well, then each of us would get a license to use each other's, but we could never sue each other for using them, right? No matter what, down the road. You could sue other people outside of the scheme, but not anyone in this scheme. And you have to give anyone, the way it works, the way it would work would be that you would have to give anyone who wants to join the patent licensing scheme a license. Anyone could participate. You can't say, no, that one's not okay. And, you know, in exchange, everyone dedicates all their patents. And the licenses remain in effect even if the patents are sold. You can take your patent out of the license and not grant any more licenses, or out of the scheme and not grant any more licenses later, but the ones that were in place would remain. So parties could always come and go as they wish, but what this does is kind of create this world where, okay, patents are going to exist. Here are these software patents. We may not like them very much, but we're going to put them in this pool, and if you want to join the pool, we'll all kind of share them, and we won't use them offensively against each other. And that's an idea that we're kind of working on developing how it would work in practice. There are a lot of questions, but it's actually quite promising, I think. Question? Right, that's a very good question, actually. The question is, so there are three things. The question is, there's the idea that things you carry out mentally can't be patented. And technically, that's still the law, though questionable in practice. But there are three things that you cannot patent. So says the Supreme Court, so says the law. Laws of nature, natural phenomenon, and abstract ideas. And your question is actually incredibly timely, because a case just came out of the Supreme Court this week, the week before, 10 days ago or something, called Mayo versus Prometheus. And this was a case about the laws of nature exception. So again, laws of nature, natural phenomenon, and abstract ideas. And this case was about laws of nature. It was, the technology was basically, I administer a drug to you, I then test to see if the drug is working in your body, and it's this process of kind of like testing to see if the drug is working. I will not really get into the details, mostly because I frankly don't entirely understand them, but the court said you can't patent this. This is a law of nature. You can't take a law of nature and like try and fancy it up and all of a sudden get a patent on it. The patent system isn't around to protect those things. Well, likewise, the patent system is not around to protect abstract ideas. And abstract ideas are, courts have said, algorithms. Abstract ideas are, many people believe, software. So I think actually, in light of this case from 2 weeks ago, we might see a little movement that makes it harder to get software patents. I don't think they'll go away, but it will be tougher. And it'll be interesting. This is all brand new. So I think it's still a little bit unsettled, but it'll be interesting to kind of see how that plays itself out. Question?
But in continuation of this abstract idea. So for example, online survey is an emotional abstract idea. And there was a case, one of those major software patent trolls were suing Walmart, ideas for basically their online survey system.
Right.
So how come this is an abstract idea?
Well, right. I mean, a lot of people think that it is an abstract idea. And recently, that was an obvious case. We haven't seen recently many patents invalidated in court because they were an abstract idea, but there are a lot of big players out there who think that these things should be considered abstract ideas, and EFF is in most instances one of those. And we file a lot of briefs in the courts and try and make this argument because I do think that a lot of this, all of those things I talked about at the beginning, why patents don't always make sense for software. Software is a building block technology. Software moves really quickly. Software has this unique characteristic that we all kind of share our work. These are reasons why you can't patent abstract ideas for that very reason, right? I mean, when people give you, obviously, the storybook example, you can't patent E equals MC squared, right? Obviously, we're talking about a different thing right now, but you can kind of extrapolate that out. And I think that the courts have kind of screwed up what is and what isn't an abstract idea, and whether or not that software has led to a lot of problems that we see now. Another really big problem, and one that I think is kind of an interesting problem that we're seeing more and more lately, is that the patent trolls are going after individuals, which we hadn't seen so much of that. We'd seen more patent trolls going, big companies going after big companies, people who can afford to fight it out in court going after each other. But there is one particular patent troll, based in Chicago actually, called Lodsys, L-O-D-S-Y-S. Some of you have probably heard of this particular outfit. Loadsys owns 4 patents, is all it does. It bought them from Intellectual Ventures, Nathan Myhrvold's company in Washington State, if any of you are familiar. Owns 4 patents, and it's been suing a whole bunch of people, big companies, smaller companies, all across the board, but it did something that we hadn't really seen before. And it took 2 of those patents last year, 2011, and it started sending threatening letters saying, you infringe our patents, to iPhone app developers and Android app developers. People who really weren't making a lot of money, people who were developing, apps for their phones in their free time and throwing them into the Android marketplace or, the iPhone app store. And this is very scary. I think this is a really bad way to do business. And there are a couple things about it that were particularly troubling. One, the technology they were suing over was for in-app upgrades, right? Click here, you want more games, click here. I'm sorry? Yeah, the update or right. In-app upgrade, it's called. So the problem is, and this is a problem with Apple and Google too, is that in order to participate in either of those companies' ecosystems, they give you that technology. So the developers weren't even coming up with this technology on their own. They had to use it if they wanted in-app upgrades, and then they were getting sued. And this company didn't sue everyone, but they did. They sued a lot. They filed a lawsuit in Texas against 11 app developers, and they're still sending, so far as I know, they're still sending threatening letters. They're asking for I believe 0.545% of your revenue. For many people, it's not a lot of money, but for some people, I think what they're trying to do is hit on the next Angry Birds, but who knows? It's really troubling for a bunch of reasons. One of the reasons is that what's exciting to people like me about the smartphone marketplace, which has its own patent disaster, but the cool thing about smartphones is it's this kind of cheaper way to share code and to share software and to share programs, right? The barriers to distribution are really falling. But now it's like, okay, so you want to write a code, you want to write a game, you want to write some other interesting app, throw it out there in the app market, but if you make any money from it, you're going to start seeing lawsuits from patent trolls. Well, that's really disturbing. I mean, that's not cool. And we have heard stories about a bunch of app developers who they have to do one of 2 things. They either have to take the in-app upgrade functionality out to avoid this problem, and studies have shown that apps make their most money from the in-app upgrade feature. It's one way that they actually get to make money. And number 2, people are taking their apps out of the US, because these are US patents. You can't use them, you can't enforce them internationally. So they're taking them out of the United States. That's terrible. Yeah? Question? Oh, 5 minutes, sorry. I only have 5 more minutes. Questions, yeah.
Comment, I guess, leads to a question about, I work in the mobile industry and UI specifically, and there's a lot of patents going on in patent wars.
Yeah.
Really fundamental aspects, building blocks, design patterns that have been established, in my opinion, for years.
Right.
But we have these oligarchies, Apple, Google, Motorola, fighting over these issues.
Really bad, right?
Yeah, and it makes me want to get out of the industry completely.
Right, and you're like preaching to the converted right now. What's going on in the smartphone world with the UI stuff and even the hardware too, I mean, it's terrible, and it creates a world in which the barrier to entry is so high that if someone comes up with a better idea or something that maybe works better, really your only option to monetize that is to license it to, Apple or Samsung or HTC. You're not going to see the next great new smartphone that someone's just going to invent and be able to get in the marketplace because it's called a patent thicket. That's all these patents are out there in the way.
So my question, then, it seems to be that this is an issue at the legislative level, and it ties into, I don't know if I'm going too far, but it ties into the understanding of our legislators, what's going on, or possibly draft, et cetera.
So we've been doing a lot of work on that. Like I said, a while ago. Fortunately, this big law was passed in 2011. So I just don't think folks in DC have a real appetite for taking on another patent reform bill anytime in the near future. I think it's just politics, and that's unfortunate. Though I'm hoping that in light of what's been going on in copyright, SOPA, PIPA, if you guys have been following that, people in DC, the flip side, are paying a lot more attention to tech policy because of that. So I'm hoping we're doing a lot of work trying to talk about the very things you're talking about. I'm cautiously optimistic, but not really.
What was the name of that law in 2011? Which one?
Is a Lady Smith America Invents Act.
Yes, question back there?
You did say that if it is an abstract idea, you cannot, it will not come under the patent. So if I am writing a particular code, or if I am writing a particular system, how can I make it look like an abstract idea so that I won't be under the problem of the patent umbrella?
That's an interesting question. I don't know if you could make it, I mean, I think what we've seen is that if you've got a patent application and you bring it to the Patent and Trademark Office and you've got enough money and enough time, eventually you'll get a patent. It might be more narrow than you want, but if you keep fighting, you know, what we see is that.
I don't want to get a patent. I just want to make sure that nobody sues me.
Right, I know.
No, and unfortunately, I wish I had a better answer for you, but if you have something that you think is abstract, but there's already a patent that exists that someone thinks you infringe, the law doesn't work, then you can say, my idea is abstract. Unfortunately, I wish you could. That would be a great idea. Maybe we could talk about that, try and figure something new out. Anyone else? Yeah?
Is there any thought into patent reform, at least to kind of stop controls, patent trolls, make patents like non-transferable? So like, at least it would stay with the company that invented.
So as a practical matter, that I don't think can ever
Happen. And a big reason why that can never happen is universities. Universities have tons of patents. Universities make a giant chunk of their money over patents, and universities often can't or don't, monetize and sell. So the politics of that they would never happen. But I don't necessarily think that's a bad idea either. Especially if you could exempt the universities. Yep.
One last question.
Challenge now by giving a person, familiar with the subject, familiar with the area, possibly the particular patent, and providing him with the information about what the patent was supposed to, what the product was supposed to accomplish, if he could develop similar products.
Yeah, and show that makes.
Well, so it's an interesting idea, and there's a lot of research showing that, inventions often happen on parallel track. Inventions, usually the next thing is kind of obvious, so there have been a lot of academic papers on this. So a lot of times the same great inventions will be happening 3 or 4 times across the country or the world. And I think that I've seen it more presented as a policy argument about getting at the same thing you're getting at. I don't know how you could, as a practical matter, make that happen, but it's an interesting idea. I think I am out of time. Thank you all so much.